Hi everybody, welcome to A Plague on Both Houses. This week in the US edition, we're going to be looking at the untimely death of Ruth Bader Ginsburg, what the implications of this are on the US Supreme Court, as well as the upcoming US presidential election. There's going to be a lot going on, so let's get right into it. Joan Ruth Bader Ginsburg, Associate Justice of the Supreme Court of the United States, passed away on September the 18th at the age of 87. This will now set off a chain of politically driven events that will dominate the US news cycle up to, including, and most likely after the US presidential election on the 3rd of November. The media of both sides of the political aisle have already started to cry foul of how the other side are hypocrites, as well as to speculate about future Supreme Court judgment implications of appointing the recently announced nominee Amy Coney Barrett, selected yesterday by President Trump. In this week's episode, we'll look at these issues and most importantly, we'll discuss a truly remarkable woman, the notorious RBG. Let's start off with the sad loss of a true lion of human equality, and I use the word equality intentionally, as RBG stood up for fairness above all, and this tended to manifest itself in seeking women's rights, for which she had personal experience on the lack thereof during her lifetime. This is perhaps best evidenced by her reciting a quote from American abolitionist Sarah Moore Grimke, who she first cited whilst arguing the 1973 Supreme Court case Fontero v. Richardson. Later, and perhaps more famously, in the 2018 CNN documentary RBG, she said, "I ask no favour for my sex. All I ask of our brethren is that they take their feet off of our necks." Further evidence of this is provided by some of the high-profile cases she argued. In Moritz v. Commissioner in 1972, she represented a man who'd been denied a caregiver deduction because of his gender. Then again for Stephen Wiesenfeld in the 1975 case of Weinberg v. Wiesenfeld, where a widower was denied survivor benefits from the Social Security, which only allowed widows to make such a claim at the time. As a person, she was one of those rare human beings who had a combination of a strong work ethic and intellectual talent, which she combined with a steel will and burning drive to serve her life's chosen purpose. The daughter of a Jewish immigrant father from the Ukraine and an American mother of Polish immigrants. Her mother was a talented high school student who was unable to pursue further studies as her family chose to fund her brother through college. This presumably contributed to the academic values passed from mother to daughter. When her mother discovered that there were a number of children in her class named Joan, she suggested to the teacher that calling her Ruth may help avoid the confusion. RBG attended Cornell University as an undergraduate, where she met her husband, who she went on to marry a month after graduating. She then worked for a short time at the Social Security Administration office, where she was demoted after becoming pregnant with her first child. She then enrolled at Harvard Law School, later transferring to Columbia Law School, all whilst being a young mother, who also had to support her husband through a bout of cancer, whilst they both studied the law. During this time, her tireless work ethic came to the fore as she studied whilst caring for her husband. This generally meant writing up notes for him that she'd collected from his classmates before then performing her own studies, till around 2 a.m. in the morning most nights. It was said that whilst in law school, she was advised that some classmates had nicknamed her Bitch. Her response to this was, "Better bitch than mouse." She compiled a glittering academic career. First woman published in the Harvard Law Review, first woman to be published in both the Harvard as well as Columbia Law Reviews, and finally graduating joint first in her class from Columbia Law School in 1959. At that time, there were no women on any federal bench, and legal jobs were hard to come by as a woman. She struggled to gain a clerkship and eventually joined academia at Rutgers Law School, and then Columbia Law School, going on to become the first female tenured professor at the latter. In 1972, she co-founded the Women's Rights Project at the American Civil Liberties Union as its director and then served as general counsel from 1973. In this role, she argued over 300 gender discrimination cases, including 6 landmark cases before the Supreme Court, winning 5 of these. Her strategy in this role was to take on cases involving specific statutes that she deemed required reform, with an ultimate goal to seeking overall gender and wider societal equality. It was this preference for incremental change on the basis of each standalone case that led her to comment that she felt the famous birthrights case of Roe v. Wade, decided in 1973, overreached. It was specifically related to the constitutionality of Texas law, but instead decided on national law. This led her to draw criticism from some women's rights advocates who felt that her support was not single-minded enough. However, she was at heart an advocate for the law and its best practice. Her support for birthrights, however, can't be in question. At a Senate confirmation hearing on this issue, she said this was central to a woman's life, to her dignity. Her preference was for the case of US Army Captain Susan Strutt, a woman who became pregnant while serving as a nurse in Vietnam, who was given the choice of having an abortion on the Army base or face immediate discharge from the service. She felt that this case concerned the US national law versus a particular state law, as for Roe v. Wade. Appointed to the United States Court of Appeals for the District of Columbia Circuit by Jimmy Carter in 1980. She served 13 years there until 1993, when she was nominated by then-President Bill Clinton to join the Supreme Court. Some say it may have actually been Hillary Clinton who may have ceded Bill's decision for RBG on the nomination. As a fellow female lawyer, she was influenced by RBG's career. At the time, now Supreme Court Justice Stephen Breyer was seen as the pundit's favourite. The Senate voted 96-3 in her favour, making her only the second woman to hold this seat after Sandra Day O'Connor. Often regarded as a fiery dissenter against the further conservative-leaning Supreme Court, she stood out in the findings for the case US versus Virginia regarding the Virginia Military Institute on the issue of gender equality. All fellow justices agreed with her findings, other than Antonin Scalia. She voted against the death penalty, for marriage equality, as well as to roll back Bush-era policies instituted as part of the War on Terror. She famously vehemently dissented with the George W. Bush argument for Bush v. Gore in the 2000 presidential election case. In recent years, RBG suffered increasing medical issues, not uncommon to a person of her age. However, again, her strong will saw her continue her duties as a justice, which included conducting her jurist duties from hospital beds. This led to her increasingly becoming a cultural pop icon, known for her strict workout routines, and increasingly she appeared in books, on t-shirts and as figurines, generally under the moniker of the Notorious RBG. The source of this nickname appears to be a law student of hers who pointed out that her initials bore resemblance to popular rapper Christopher Wallace, who was also known as the Notorious B.I.G. Sadly, perhaps her final first, RBG became the first woman to lie in state in Washington at the US Capitol. It's expected that she'll be buried next to her husband at Arlington National Cemetery in the coming week. The thing that strikes an observer most is that RBG was never bitter for the struggle she had to endure whilst making her way to the top. She didn't resent the establishment that tried to keep her and her gender down. Rather, she took them on at their own game and beat them with logic and arguments. We can only speculate now, but I wonder how a young RBG would have reacted in the current climate, where protests and people calling for equality see fit to seemingly want to destroy property and the elements of society in which they live. Would RBG have been a modern-day looter or formed part of the cancel culture of social media? We'll never know the answer to this. The Supreme Court. Let's start with some background on the US Supreme Court. It's the highest court in the US judiciary system, composed of 9 justices, 1 chief and 8 associates. The President nominates the Supreme Court Justice for vacant seats, the Senator then to provide advice and consent via a simple majority vote. Supreme Court seats are lifetime appointments, provided that a justice maintains a good standing, and these roles are meant to be free from political persuasion, which we'll come to in a minute. The Supreme Court was originally created by the US Founding Fathers at the Constitutional Convention in 1789. There are no prerequisite requirements for age, experience or citizenship of Supreme Court justices. It wasn't until 2 years later that the first Congress passed the Judiciary Act of 1789, which established a court of 6 justices, responsible for ensuring the constitutionality of laws enacted by the executive and legislative branches. This was signed into law by George Washington. This now meant the federal court system composed of 3 tiers that starts at the state level, where a federal judge presides over a district court. These are then grouped into 3 geographical locations that are covered by circuit courts, which act as trial courts and to hear appeals. This then leaves the Supreme Court as the final decision maker. The inherent issue with appointments being made by the President, who's a partisan politician, means that nominees are naturally chosen with views aligned to the party of the sitting President. Pundits point to the 2010 nomination of Elena Kagan to the Supreme Court as the turning point, where all future nominations then split along partisan and ideological lines. There are now currently 5 Conservative justices who share common ideals with the Republican Party. Then RBG had been the senior member of 4 justices who form the so-called Liberal wing, who are also referred to as progressives. They're closely aligned in philosophy to the Democratic Party. Gender-wise, the balance sits at 6 men and 3 women, which Trump has confirmed he will maintain. Recently, Antonin Scalia's seat remained vacant for nearly a year until Trump won the 2016 election and then nominated Neil Gorsuch, who took his seat in 2017, thus returning the ideological status quo to the bench. In 2018, Justice Anthony Kennedy retired, and he was seen as a moderate, who often crossed the divide when voting on issues. With Donald Trump as a Republican president and the Senate also under the GOP's control, Brett Kavanaugh was then nominated. He's a conservative, and his appointment saw the court's ideology shift to the right. There have been 16 situations when a Supreme Court seat has become vacant in a presidential election year prior to Election Day. Then an additional 10 in the period after the election, but before the inauguration, often referred to as the lame duck period. In recent times, Joe Biden famously stood up in the Democratic Majority Senate in 1992 and encouraged George H.W. Bush to delay nominating Clarence Thomas as Supreme Court Justice until after the election. Roll forward to February 2016, when Antonin Scalia dies whilst a sitting justice, during a time that the Republicans control the Senate, and Barack Obama nominates Merrick Garland. This was 237 days before the election, and Mitch McConnell, as Senate Majority Leader, refused to bring the vote to the Senate floor on account of it being during an election year. This time, Joe Biden switches his stance and makes the argument that the vote should be upheld. In a speech last Monday, Mitch McConnell pointed out that aside from a somewhat unique exception when Lyndon Baines Johnson controlled the Senate and couldn't get his nomination approved, whenever the President shares a party with the majority in the Senate, nominations are always approved. He concluded by saying, "The historical precedence is overwhelming and it runs in one direction. If our Democratic colleagues want to claim they are outraged, they can only be outraged at the plain fact of American history." The Washington Post reports Mitch McConnell is planning to meet with Coney Barrett on Tuesday, according to one of his aides.